Questions and answers in Criminal Law, Part 1. Question: what is a composite crime? Answer: a composite crime, also known as a special complex crime, is composed of two or more crimes that the law treats as a single, indivisible, and unique offense for being the product of a single criminal impulse. That is a composite crime, a product of a single criminal impulse. How about a complex crime? What is a complex crime? Answer: in a complex crime, multiple crimes occur from a single criminal intent, resulting in just one criminal liability. For example, estafa through falsification of a public document is considered one crime legally, even though it involves two components. This differs from a situation where separate criminal intentions lead to multiple crimes, each carrying its own liability. Again, in a complex crime, multiple crimes occur from a single criminal intent, resulting in just one criminal liability. Now, according to Article 48 of the Revised Penal Code, complex crime, despite involving multiple offenses, are treated as a single crime and are punished with one penalty. Essentially, although multiple crimes are committed, they are viewed as one crime both legally and morally because the offender has only one criminal intent. Even when one crime is necessary to commit another, the intent remains singular. Now, what is a penalty for complex crime? So when a single act constitutes two or more grave or less grave felonies, or when an offense is a necessary means for committing the other, the penalty for the most serious crime shall be imposed, the same to be applied in its maximum period. Again, the penalty for the most serious crime shall be imposed. Question: what does it mean for the accused to be liable for the complex crime of estafa through falsification of public documents? Answer: it means that the accused has committed both estafa and falsification of public documents, but because these crimes stem from a single criminal intent, they are treated as one crime with a single criminal liability. Question: why shouldn't the component crimes of estafa and falsification be considered separately? Answer: because both crimes result from the same criminal intent, they are not treated as separate crimes, but as part of one complex crime. Treating them separately would misunderstand the concept of a complex crime. Question: what is required for a conviction of the complex crime of estafa through falsification of public documents? Answer: a conviction requires proving the elements of both estafa and falsification. However, they are not considered independent crimes, but components of one complex crime. So again, elements of both crime still needs to be proven. Question: what does Article 48 of the Revised Penal Code state about complex crime? Answer: Article 48 of the Revised Penal Code states that multiple crimes resulting from a single criminal intent are treated as one crime with one penalty. Question: why is it incorrect to treat estafa and falsification separately in this context? Answer: treating them separately would ignore the nature of a complex crime and the principle that they are components of one crime, not separate crimes with individual penalties. This misunderstanding disregards the distinction between formal plurality, which means one criminal intent, and material plurality, which means separate intents. Now let's talk about circumstances modifying criminal liability. Question: what happens if an offender uses their public position to commit a crime, even if there are mitigating circumstances? So answer: if an offender uses their public position to commit a crime, the penalty will be imposed at its maximum, regardless of any mitigating circumstances. This rule under Article 62 of the Revised Penal Code, as amended by Republic Act 7659, aims to combat graft and corruption in the government. In other words, mitigating circumstances does not have a weight if the offender uses their public position to commit a crime. The penalty that will be imposed will still be at its maximum. Question: can the mitigating circumstance of being a minor be considered if the offender used their public position to commit a crime? So this time, this is a public officer. It's a hypothetical question. A public officer committing a crime, but the public officer is a minor. Will being a minor be considered a mitigating circumstance? So the answer is no, because as we all know, minors cannot hold public positions, and thus, therefore, they cannot commit a crime by taking advantage of such a position. Question: M and J were drinking with others when they had a heated argument. So M left, threatening to sweep them or kill them. He soon returned with a knife, taunted J, and stabbed him in the chest before fleeing. Can the aggravating circumstance of treachery be applied to M's attack? So was there treachery? The answer is no. So even though the attack was sudden, it did not constitute treachery. Why? The prior argument and M's threat to sweep them or kill them was a sufficient warning on J of the impending assault. So it cannot be considered treacherous. Question: was the killing then attended by the aggravating circumstance of evident premeditation? So was there evident premeditation? So the answer is no. Although M's threat and return with a knife showed his intent to commit the crime, so yeah, there was an intent to commit the crime. However, there was not enough time between his resolve and the attack for premeditation. It was very short time. The 3 minutes between his threat and the stabbing were not enough for him to reflect on his actions. When we say evident premeditation, this requires a period of cool thought and reflection. And definitely in this case, this was absent. So there is no evident premeditation. Let us talk about good conduct allowance. So question: can good conduct allowance reduce the criminal liability of a person who is not yet convicted but is already under preventive imprisonment? So the answer is yes. With the passage of Republic Act 1059-2, good conduct allowance can already partially reduce criminal liability for those under preventive imprisonment. Before Republic Act 1059-2 was passed, only prisoners convicted by final judgment and are already serving their sentence in jail could earn good conduct allowance. However, with the passage of the Republic Act 1059-2, detention prisoners can now also earn this allowance. Question: how is the period of preventive imprisonment handled under Republic Act 1059-2? So if a person is on preventive imprisonment, meaning there's no conviction yet, but he's already in jail, how is this handled? So the answers are: first, there is credit for preventive imprisonment, meaning offenders or accused who undergo preventive imprisonment have the full time credited towards their sentence of deprivation of liberty. In other words, the days, the months, the years that they're in jail counts towards their sentence as a credit. Another one is voluntary agreement. If the detention prisoner voluntarily agrees in writing that he will abide by the same disciplinary rules as convicted prisoners, then they will be credited with the full time of preventive imprisonment. In other words, they would now assume the role that they are convicts. And so they will be treated like convicts. And if they voluntarily agree to that, the time that they serve under preventive imprisonment will be credited with full time once their sentence comes out. However, if they don't agree or in non-agreement, if the prisoner does not agree to abide by the same rules with a convict, they still get credited for their detention time, and they will be credited with 4/5 of the time of preventive imprisonment. How about release provision? So when the period of preventive imprisonment already equals the maximum possible imprisonment for the offense the accused is charged, the accused shall be released immediately pending trial or appeal with credit for good conduct time allowance. So even though the case is not yet closed, if the amount of time served in preventive imprisonment already equals the maximum possible imprisonment if charged or found guilty in such offense, then the accused shall be released immediately as if he or she has already served his sentence. Now, what are exclusions? So certain categories such as recidivists, habitual delinquents, escapees, and those charged with heinous crimes are excluded from these benefits or the benefits under this act. Now, how about the person on destierro? So, if the maximum penalty for the offense of destierro or banishment is already achieved, the accused shall be released after 30 days of preventive imprisonment. Okay. Now, question: how is criminal liability partially extinguished under Republic Act 1059-2? So there are ways. One is conditional pardon. Conditional pardon is a form of executive clemency from the president. The president or the chief executive grants forgiveness for a crime under a certain condition. It partially extinguishes criminal liability either by reducing it or nullifying the penalties imposed on the offender. In other words, the offender is still an offender. It's just that his criminal liability is either reduced or nullified. And this executive clemency can only come from the president or the chief executive under the power for conditional pardon. We also have commutation of sentence. So when we say commutation of sentence, this involves the reduction of a sentence imposed by a court into a lesser penalty or lesser term of imprisonment. Now, this action by the executive authority partially extinguishes criminal liability by mitigating the punishment originally imposed. And we also have good conduct allowances, which is under Republic Act 1059-2. Offenders can earn good conduct time allowances while undergoing preventive imprisonment or serving their sentence. These good conduct allowances allows for a reduction in the actual time served in prison, and this deduction or reduction is based on the demonstration of good behavior and compliance with institutional rules. This also partially extinguishes criminal liability by shortening the duration of imprisonment or detention. Question: how does Article 97 of the Revised Penal Code address allowances for good conduct? So this is the rule. In the first 2 years of imprisonment, an offender with good behavior earns a deduction of 20 days for each month served. Okay? On the 3rd to 5th year of imprisonment, the deductions increases to 23 days for each month of good behavior. So they earn days every month. On the 6th to 10th year, the deduction is 25 days for each month of good behavior. On the 11th year and onwards, the deduction is 30 days for each month of good behavior. An additional deduction at any time during imprisonment of 15 days per month for study, teaching, or mentoring service. So those are the allowances for good conduct. Question: does filing an appeal affect an inmate's entitlement to allowances for good conduct under Article 97? So if the inmate files for an appeal, does this affect his entitlement for allowances for good conduct? The answer is no. Filing an appeal does not deprive an inmate of his entitlement to the allowances for good conduct as specified in Article 97 of the Revised Penal Code. Question: what does Article 98 of the Revised Penal Code provide regarding special time allowance for loyalty? So what is this special time allowance for the inmate showing loyalty? So when is that special time allowance for loyalty possible? There are two conditions or two scenarios. Number one, evading preventive imprisonment or sentence, meaning there is a deduction of 1/5 of the period of his sentence is granted to a prisoner who evaded preventive imprisonment or the service of his sentence under circumstances listed in Article 158 and surrenders within 48 hours following a proclamation of the passing away of the calamity or catastrophe. Meaning, there is an instance, instance as listed in Article 158, and this prisoner who tried to evade his sentence actually surrenders within 48 hours. If he does that, he has a deduction of 1/5 of the period of his sentence. Now, for those who choose to stay despite the calamity, there is a deduction of 2/5 of the period of the sentence if the prisoner chooses to remain in the place of his confinement despite the existence of calamity or catastrophe listed in Article 158. So, does Article 98 apply only to prisoners undergoing preventive imprisonment, or does it also apply to those serving a sentence? So that Article 98, wherein it grants prisoners, those who come back after 48 hours or those who stay, are applicable for both prisoners or inmates undergoing preventive imprisonment or those who are already serving a sentence. Now, there was a mention of circumstances listed under Article 158. So what are these circumstances? Answer: Article 158 of the Revised Penal Code enumerates calamities and catastrophes under which a person who has evaded preventive imprisonment or service of his sentence may be entitled to special time allowance for loyalty. Now, these circumstances include emergencies such as earthquakes, floods, conflagrations, and other similar situations that are officially declared by competent authorities. So there must be a declaration. Now, who has the authority to grant time allowances for good conduct under the Revised Penal Code? So time allowances for good conduct are granted by the Director of the Bureau of Corrections, the Chief of the Bureau of Jail Management and Penology, or the Warden of Provincial, District, Municipal, or City Jails whenever lawfully justified. Once granted, these allowances cannot be revoked. Now, what penalties are imposed for violating provisions of RA 1059-2? Any public officer or employee who violates the provisions of RA 1059-2 is subject to 1 year of imprisonment and a fine of 100,000 pesos and perpetual disqualification to hold office. So question is, what are examples of these violations under RA number 1059-2? So one is when that public officer refuses to grant good conduct allowance. So if the director of the Bureau of Correction or the chief of the Bureau of Jail Management and Penology or a warden of a jail unjustly refuses to grant or withhold a rightful good conduct allowance to a qualified prisoner, such is an example of violation. Second is revoking granted allowances. As we said, these allowances are irrevocable. It can only be revoked upon lawful justification. Third, misapplication of allowance criteria. So this is a violation when a public officer applies the criteria for granting good conduct allowances inconsistently or unfairly, not in accordance with the law's provisions. And finally, failure to comply with procedural requirements. So if a public officer fails to comply with procedural requirements set forth in RA 1059-2, when they grant or administer good conduct allowances, such is also a ground for violation. So how are allowances for good conduct modified under RA 1059-2 as compared with the old law? So answer, under the old law, allowances for good conduct were more limited. Like for instance, during the first to second year of imprisonment, only 5 days for each month of good year. And in the third to fifth year, only 8 days. And so on and so forth. So the amendment introduced under RA 1059 grants a new allowance of 15 days for each month of study, teaching, or mentoring service, which was not permitted previously. And as you also noted, the days granted for each year of service is also increased. Importantly, the appeal of an accused does not deprive them of the good conduct allowance under the amended law. Now, prior to RA 1059-2, who could be granted special time allowance for loyalty? So that's when there is this emergency and there were prisoners who tried to escape and come back versus those who stay. So prior to RA 1059-2, only prisoners who escape from a penal institution under the specific conditions could be granted special time allowance for loyalty. Now, this rule was considered unfair because it encouraged escapism to benefit from the law. So there was an amendment under RA 1059-2, and the amendment was now more special time allowance for those who stay. Now, this encourages prisoners not to escape because now they're granted 2/5 reduction of their sentence term compared to 1/5 of those who tried to escape and come back. But at least they also have benefits. So does mere detention automatically entitle a prisoner to time allowances? No, mere detention does not automatically entitle a prisoner to time allowances. These allowances are granted based on the behavior of the prisoner while incarcerated. So once granted by the appropriate authorities, such as the Director of the Bureau of Corrections or the Chief of the Bureau of Jail Management and Penology, or warden of provincial, district, municipal, or city jails, these allowances cannot be revoked. Question: under heinous crimes, what are considered heinous under the law? Answer: there are 12 lists of heinous crime, and these are your treason, qualified piracy, qualified bribery, parricide, murder, infanticide, kidnapping and serious illegal detention, robbery with violence against and intimidation of persons, destructive arson, rape, plunder, and certain provisions under the Dangerous Drug Act. So what was the effect of RA 9346 on the imposition of penalties for heinous crimes? So answer: RA 9346 prohibited the imposition of death penalty in the Philippines. As a result, penalties for heinous crimes that were previously punishable by death under RA 7659 are now reduced to reclusion perpetua or life imprisonment under the revised penal code and to life imprisonment under special penal laws. Now let's talk about direct assault. How is direct assault committed? Answer: direct assault occurs in two ways. One, it can be by force or intimidation, and two, against persons in authority. So when we talk by force or intimidation, this is when individuals use force or intimidation to achieve goals similar to those in crimes of rebellion or sedition without a public uprising. This is considered direct assault. Also, when direct assault occurs against persons in authority, when individuals attack, use force, seriously intimidate, or resist a person in authority or their agents while they are performing official duties or due to their past duties without a public uprising, that is also considered direct assault. So what are elements of direct assault against persons in authority? So direct assault against persons in authority requires the following elements to be present. There are 5 elements. First, the offender commits an attack, uses force, makes serious intimidation, or resists. Second, The victim is a person in authority or their agent. Third, at the time of the assault, the person in authority or the agent is either engaged in actual official duties or he is assaulted because of his past official duties. Fourth element, the offender knows that the victim is a person in authority or their agent performing official duties. And fifth, there was no public uprising at the time of the assault. So this is considered direct assault. Now let us go to felony. What is the classification of felony if the imposable penalty is a fine of 40,000 pesos? So under the revised penal code, it states that light felonies are those infractions of law or commissions of which the penalty of arresto menor or a fine not exceeding 40,000 pesos or both is provided. So the answer is light felonies. How about instigation and entrapment? Distinguish instigation from entrapment. So answer, in an instigation, the officer of the law or their agents incite the accused into committing an offense which he or she would otherwise not commit and has no intentions of committing. But in entrapment, the criminal to commit the offense originates in the mind of the accused, and the law enforcement officers merely facilitate the apprehension of the criminal by using schemes. Okay? In other words, instigation is a trap for the unwary innocent, while entrapment is a trap for the unwary criminal. Self-defense. In invoking self-defense, what is the test to prove presence of unlawful aggression? So the presence of unlawful aggression is proven when the victim's aggression puts in real peril or danger the life or personal safety of the person defending himself. And that danger or peril must not be an imaginary threat. It must be real peril or danger of the life or personal safety of the person defending himself. So what are the elements of unlawful aggression? Okay, so the accused must establish concurrence of 3 elements of unlawful aggression. So it is unlawful aggression when these 3 elements are present. First, there is physical or material attack or assault. Second, the attack or assault must be actual or imminent. And third, the attack or assault must be unlawful. Question, what are the kinds of unlawful aggression? Answer, as stated earlier, the aggression can be actual or material, or it can be imminent. Actual or second one is imminent. So when we say actual or material unlawful aggression, this means there is already an attack with physical force or with a weapon. This is an offensive act that positively determines the intent of the aggressor to cause the injury. So there is a positive overt act that determines the intent of the aggressor to cause the injury. That's your actual or material unlawful aggression. If it's not actual, it is only imminent. So when we say imminent unlawful aggression, this means that the attack is impending or at the point of happening. Although it's not merely a threatening attitude, it's not also imaginary. But such act must be offensive and positively strong. Like, for instance, aiming a revolver at another with intent to shoot. Okay. Now let's talk about conspiracy. What is the focus of the inquiry to determine if the accused conspired with the main perpetrators of the crime? Now answer, to determine if an accused conspired with the principal by direct participation. The focus of the inquiry should necessarily be on the presence of overt acts of the accused. So we look at the overt acts of the accused before, during, and after the commission of the crime by the principal by direct participation. So we look at the overt acts of the accused. What was he doing before, during, and after the principal committed the crime by direct participation? Mere knowledge, acquiescence, or approval of the act without actual cooperation and agreement to cooperate is not enough to establish conspiracy. So when there is no cooperation or no agreement to cooperate, that is not conspiracy. Mere presence also does not make them parties to it, absent any active participation in the furtherance of the common design or purpose. So even if the person is there, but he does not do any action at all to furtherance the common design or purpose, then he cannot be charged with conspiracy. So where the only act attributable is an apparent readiness to provide assistance, but with no certainty to its ripening into an overt act, then such is not conspiracy. So, in other words, for conspiracy to be established, overt acts have to be established. Now, question, how to determine if the accused is to be considered principal by indispensable participation or an accomplice? So answer, to be liable either is a principal by indispensable cooperation or as an accomplice, the accused must unite with the criminal design of the principal by direct participation. Records must show that the accused knew the main perpetrator of the crime was going to commit the said crime, thus creating no doubt as to the accused's criminal intent. In other words, he knows what was the plan of the principal assault or principal person who committed the crime. Because if the accused knew the main perpetrator of the crime was going to commit the said crime, then there's no doubt that it is also his criminal intent. Legal culture demands the presentation of proof beyond reasonable doubt before any person may be convicted of any crime and deprived of his life, liberty, or even property. So the hypothesis of his guilt must flow naturally from the facts proved and must be consistent with all of them. Moral certainty, not mere possibility, determines the guilt or innocence of the accused. Question. Compare and contrast conspirators and accomplices. Answer. Conspirator and accomplices have one thing in common. They know and they agree with the criminal design. So again, conspirators and accomplices, they know what's going to happen. The conspirators know the criminal intention because they themselves have decided upon such a course of action. So they are part of the plan, the conspirators. However, accomplices only came to know about it after the principals have reached the decision. and only then do they agree to cooperate in its execution. In other words, the conspirators are part of the planning, accomplices are in the execution. Conspirators decide, accomplices concur. Conspirators are the authors of the crime, accomplices are merely their instruments. Now let us talk about theft and robbery. Question: what is apoderamiento? Answer: apoderamiento means unlawful taking. It refers to taking personal property without the owner's consent, and in taking there was use of violence, intimidation, force against a person or thing. And once the offender gains possession of the property, even if they haven't disposed of it yet, the offense is already considered complete. So once the offender gains possession of the property, the offense is complete. Apoderamiento, unlawful taking. So under the rules of court, there is a presumption that a person found in possession of a recently stolen property is the one who took it and committed the entire wrongful act. So be careful with being in possession of recently stolen property, because the court has a presumption that it is the one who took it and committed the entire wrongful act. Now, how about animus lucrandi? What does it mean? Animus lucrandi means intent to gain. So it refers to the internal intention or motive to acquire some form of benefit or advantage from an unlawful act. In legal terms, the intent to gain is presumed from the unlawful taking of personal property, regardless of whether actual gain occurs. So the concept of gain extends beyond financial benefits to include any advantage or benefit that the offender expects from their actions. For example, simply using the taken property without the owner's consent constitute gain. Even if the property is later abandoned, the initial act of taking it demonstrates the offender's intent to benefit from the unlawful act. So, animus lucrandi, there was an intent to gain. Question: if a robbery is committed by several people in a motor vehicle on a public highway, is it automatically considered highway robbery? No. The answer is no. Even if robbery is committed by several individuals using a motor vehicle on a public highway, this does not automatically classify it as a highway robbery or brigandage under PD number 532. The crime remains robbery in a band, which involves multiple offenders working together to commit robbery. Why? Because highway robbery specifically applies when it can be proven that the offenders organize themselves to commit the crime on a public highway, meaning that's their primary reason why they organized. Now, if a person is caught in the act of pimping, what penalty is imposed by law? So as of now, there is no specific penalty for pimping under the current law. The reason behind a Republic Act number 10158 enacted in March 27, 2012, decriminalized vagrancy, which previously addressed offenses related to prostitution. So pimping, which involves arranging or facilitating prostitution for profit, historically fell under vagrancy laws targeting immoral conduct. However, with the decriminalization activities like pimping are no longer prosecuted under the previous statutes. Let us go to homicide and murder. Question. A and B were out drinking with others when they got into a heated argument. As tensions escalated, A abruptly left the group warning them, "Hintayin ninyo ako dyan. Wawalisin ko kayo." 3 minutes later, A returned with a knife, directly confronted B, taunted him, and quickly stabbed him in the chest before leaving. So what crime did A commit? Answer. A committed homicide. So why homicide and not murder? Because despite his threat and the preceding argument, the circumstances do not support treachery or evident premeditation. When we say treachery, this requires a sudden and unexpected attack. But in this case, V was warned beforehand. Evident premeditation involves a period of calm reflection between intent and action, which was also lacking as the attack swiftly followed A's threat. Therefore, the crime is classified as homicide and not murder due to lack of treachery and lack of premeditation. Let's go to rape. Under what circumstances is rape legally considered to have occurred? Answer. Rape is legally defined as occurring when the victim is under 12 years of age or is mentally incapacitated, even if none of the specific circumstances listed in Article 266A are present. The interpretation of Article 266A hinges on the individual's ability to give genuine consent, which is determined by their mental age rather than their chronological age. So if a woman over 12 years old has a mental age equivalent to that of a child under 12, the accused can be charged with rape even if the victim apparently consented to the sexual acts. This legal principle ensures that individuals with developmental or mental disabilities are protected from sexual exploitation, paralleling the protection extended to minors under 12 years old. Question. Would the accused be guilty of statutory rape under Article 266A if the victim, age 22, has a mental age of 4 to 5 years? So the question is, will the crime be statutory rape? The answer is no. In the scenario described, the victim is 22 years old but has a mental age of 4 to 5 years. The offense then committed would be classified as simple rape under the revised penal code. This is because the victim is considered deprived of reason due to their mental abnormality or deficiency, regardless of their chronological age. Therefore, the accused cannot be charged with statutory rape because in statutory rape, it specifically applies to carnal knowledge of a woman below 12 years old. Question. Can the accused avoid conviction for rape against his stepdaughter by arguing that force, threat, or intimidation must be proven under the revised penal code? And since she was 15 years old at the time, this requirement applies. So the answer is no. The contention is not valid. In cases of rape committed by a close kin, such as a victim's stepfather, moral ascendancy substitute for the requirement to prove force, threat, or intimidation. This principle applies regardless of the victim's age, as long as the accused holds a position of authority or influence over the victim due to familial relationship. The prosecution does not need to establish force, threat, or intimidation, as moral ascendancy is evident. Question: what is the probative value of the sweetheart theory as a defense in rape cases? Answer: the sweetheart defense holds little probative value in rape because the existence of a romantic relationship between the accused and victim does not excuse the use of force or the lack of consent. Even if they were in a relationship, the core issue in rape remains the non-consensual nature of the sexual act. Love or prior intimacy does not justify or excuse rape, as the offense hinges on the absence of voluntary consent. Is the rule against sweetheart defenses absolute? The answer is no, it is not. The defense of consensual sexual intercourse, even if raised in the context of a romantic relationship between the accused and the victim, should not be summarily dismissed. While the existence of a romantic relationship does not automatically negate rape charges, courts should also carefully evaluate all evidence presented, including the nature of the relationship, the circumstances surrounding the alleged offense, to determine whether there was consent freely given or was there coercion. Another question. At around 9 o'clock in the morning of March 14, 2006, a housemaid, received a text message from the accused asking if they could meet. He was then working as a security guard near AAA's place of work. AAA accepted his invitation, met with him in Santa Ana, Manila, where they boarded a passenger jeepney bound for Rizal Avenue. Arriving in Santa Cruz, they entered Jollibee on Rizal Avenue and ordered food. Later, they went to a nearby Aroma Motel, and according to AAA, she was raped by the accused while inside the motel. The accused denied having committed the crime, insisting that they were lovers. Is the accused guilty of the crime of rape? So answer, no. The accused cannot be found guilty of the crime of rape based on the circumstances presented. Both accused and AA were adults capable of consenting to sexual intercourse. The events leading up to the alleged incident suggest mutual understanding and willingness to engage in intimate relations. Despite AAA's assertion that she was raped, there was no evidence of resistance or protest when they entered the motel, indicating apparent consent. Under Philippine law, consent is a crucial element in determining whether rape has occurred. In this case, facts are established, the voluntary nature of their interactions, and the absence of resistance. The accused's assertion that they were lovers further support this view, as it aligns with the legal principle that mutual consent negates the criminal intent required for rape. Thus, without evidence of force, threat, or intimidation, and considering the apparent consent and mutual understanding between the parties, the accused cannot be convicted of rape. Question. The prosecution was able to prove that AAA suffered bruises and abrasions on her left breast and on her right hand, which they argued tend to prove that the accused employed force on her. Based on the medical legal findings of these injuries, can it be concluded that she was subjected to bodily harm by the accused to force himself on her? Answer is no. Under the Philippine law or the revised penal code, rape occurs under various circumstances, including when there is force or intimidation. In this case, while the prosecution argues that AA's bruises and abrasions indicate force, these findings alone do not conclusively prove lack of consent, because injuries can also occur during consensual sexual encounters. Therefore, without additional evidence showing lack of consent or force beyond injuries, the argument that the injuries prove forceful rape is not tenable. Question. The appellant contends that while AAA alleged she was raped multiple times in 1999 at age 8, the medical legal report showed only one deeply healed hymenal laceration at 6 o'clock position. It is argued that another male could have caused this, given the examination occurred in 2005 when AAA no longer lived with the appellant. Is this contention tenable? The answer is no. The contention is not tenable. The appellant's argument that the single-healed laceration in AAA's hymen could have been caused by someone else lacks merit. The timing of the medical examination years later does not discount prior abuse, and the healed nature of the laceration suggests it wasn't recent or caused by recent activity. In Philippine law, hymenal lacerations are significant in cases of rape, but AA's credible and consistent testimony, supported by medical findings, suffices to establish carnal knowledge. The Supreme Court values rape victims' testimonies considering the trauma involved. Therefore, while hymenal lacerations are strong evidence, they aren't necessary when credible testimony and medical evidence are present. Thus, AAA's testimony, backed by evidence of a healed hymenal laceration, remains credible despite suggestions otherwise supporting her allegations of rape. Question. Did the resistance of AAA during sexual intercourse result in the crime of rape being committed against her? Answer. No. The evidence shows that the accused did not employ force, threat, or intimidation against AAA at any point. AAA did not express any rejection when the accused initially asked to have sex, and only showed resistance by moving when she felt pain during the act. This resistance was neither clear nor tenacious. The Supreme Court has held that resistance must be unequivocal and persistent to constitute rape. AAA could have resisted from the start, but chose not to, and her mid-act discomfort does not meet the standard for rejecting the accused advances. Thus, the accused cannot be convicted of rape based on this scenario. Let's talk about forcible abduction. Question. Can a person be convicted of the complex crime of forcible abduction with rape if the primary objective was to rape the abducted woman? Answer. The accused is guilty of rape. The prosecution was able to prove the elements of forcible abduction under Article 342 of the Revised Penal Code, which include the taking of a woman against her will with lewd designs. So forcible abduction is taking of a woman against her will and accompanied by lewd designs. However, when the primary objective of the abduction is to commit rape, the crime of forcible abduction is absorbed into the crime of rape. Therefore, the accused should be convicted of rape, not the complex crime of forcible abduction with rape. Kidnapping for ransom. What are the elements of the crime of kidnapping for ransom? The crime of kidnapping for ransom requires the prosecution to establish the following elements. First, that the accused was a private person. Second, that the accused was kidnapped, detained, or deprive another person of their liberty. And the kidnapping was illegal, and the victim was kidnapped or detained for ransom. Again, the accused is a private person, and the accused detained another person or deprived another person of his liberty. The detention was illegal, and the detention was for ransom. Question: if the agents of the Philippine Drug Enforcement or PDEA kidnap or detain someone for ransom, what crime is committed? So, if PDEA agents detain a private person to extort money, this act cannot be considered within their official functions. So, if proven, they are guilty of serious illegal detention, and their status as law enforcement officers does not grant them immunity from the criminal acts. Let's go to estafa. Anita Capulong and her husband executed a promissory note, post-dated checks, and a deed of chattel mortgage for their Isuzu truck in favor of Francisca de Guzman for 700,000 pesos. Later, they induced de Guzman to lend them the truck certificate of registration and official receipt under false pretense. Once in possession of these documents, they concealed them, preventing the chattel mortgage registration and replacing the truck's motor. Anita was convicted of estafa under the revised penal code. However, Anita contends that the CR and OR are not documents of indebtedness as required to be charged of estafa. Is Anita correct? So answer: Anita is not correct. Estafa, as defined under the revised penal code, involves deceit or fraud that causes damage. So specifically, the revised penal code penalizes the removal, the concealment, the destruction of documents or papers that may cause prejudice or damage. In this case, the CR or the OR, the CR and OR of the vehicle, while they're not traditional evidence of indebtedness, but they are essential parts of the chattel mortgage. Thus, concealing these documents, Anita prevented de Guzman from registering the mortgage and foreclosing on the truck, thus causing harm or prejudice. Now, this deceitful act falls under the definition of estafa as it involved fraud, misrepresentation, and caused damage. So again, what are the two essential elements in the crime of estafa? So the two elements are fraud and injury. Specifically, the elements are: the accused defrauded another by abuse of confidence or deceit, and this leads to damage or prejudice that is capable of pecuniary estimation. So for estafa by means of deceit, the following are required. So for deceit, there must be a false pretense or a fraudulent act, and this must occur before or during the commission of the fraud. And the victim relied on the deceit and parted with his money or property. And for that, the victim suffered damage as a result. Now, what are elements of syndicated estafa? Now, a syndicated estafa are, number one, committing estafa or other forms of swindling as defined in the revised penal code. And the commission of estafa or swindling by a syndicate involves 5 or more individuals collaborating to carry out the unlawful activities. And third, the defraudation resulted in misappropriation of funds contributed by stockholders, members of rural banks, cooperatives, samahang nayons, farmer associations, or funds solicited by corporations or associations from the general public. Now, while simple estafa's penalty depend on the amount of damage caused, in a syndicated estafa, this is punishable by life imprisonment to death, irrespective of the value of the defraudation. Question. 8 members of Cooperative E Board of Directors are accused of syndicated estafa. Allegedly, they conspired to defraud the cooperative through irregular contracts, leading to misappropriation of millions in funds. So will the syndicated estafa complaint against them succeed? So the answer is no. For a complaint of syndicated estafa to succeed, it must be proven that the accused formed or managed an association with at least 5 members and used this association to defraud its own stockholders, members, or depositors. In this case, the allegation against the board members of Cooperative E did not establish that they operated the cooperative with the intention of defrauding its members. Furthermore, the elements required for simple estafa under revised penal code were not met because there was no evidence that the board members received funds of Cooperative E in trust or for administration, nor was there any proof of misappropriation or conversion of such funds. All right, that's it for part 1. If you find this video useful and substantial, don't forget to like, share, and subscribe. Thank you very much.